Ladies and gentlemen, welcome to the People's Law School. Tonight we have a real treat. We have Lee Leggett, Huntsville's own Lee Leggett, to come and talk to you tonight about national security law. I want you to know that Lee is, or was, an FBI lawyer for 30 years, and he practiced in the national security field during most of that time. He's originally from Mississippi, down there, and everybody from Mississippi, he said, down in Mississippi. So where? And every one of them saying, a little town in Mississippi. I said, where? He said, halfway between New Orleans and Jackson. Got it. So, Macomb, right?
That's right.
Macomb. But anyway, so he went on to the University of Southern Mississippi, where he got 1 degree, and then went on to the Ole Miss and got his law degree. Thereafter, practiced for a while back home, and then he went into the FBI, and he's been in Washington, D.C., and New York City, and other places, I believe Houston, learning what he's going to share with you tonight. I'll tell you what, Lee has just been back a few years, but I want you to know that I heard him speak at a seminar. About 2 years ago, the local law bar, Tazewell Shepherd, put together this thing where we have lectures for lunch, and we get paid as CLE credit, and so you get to charge an hour so you don't have to do your schooling. You can go to Gibson's and listen to a good speaker. Well, I heard Lee Leggett, and I asked my son, I said, who is that guy? We've got to have him. He's got to be on the People's Law School. So, sure enough, here he is. I'm proud of having him here, but enjoy what he has to say, and I present to you Mr. Lee Leggett.
Thank you so much.
Thank you, sir. Thank you, thank you.
Let me put this down because it interferes with me. As Alan said, he called me this afternoon and called me out of bed. I've actually had a cold all weekend. So if I sound a little weak, it's because I probably am. If I start acting kind of addled, it's probably because I'm at that age where I act a little addled. If I start confusing things, I'm going to need you all's help. So we're going to go over, this is be kind of a survey course. We're going to go over a little bit of what I consider to be a national security law and how we can address it, and what you all need to know, what we all need to know about what our country does to protect us, and what the rules of the game are and how they're played, a little bit. So I expect to get some questions. I'm going to really need y'all's help. I need questions because that's going to help me develop what you're really interested in. But I think to get started, let's start with the Constitution, because everything that we say and everything that the government does has to have some sort of constitutional basis. So initially, when you start talking about national security law, you have to talk about the Constitution. Now, the Constitution says what? It provides the framework for our government, and it divides it into 3 separate branches of the government, and every one has a role, somewhat to say, in national security law, and we're going to talk about that. First thing we need to say is Article 1 says what the congressional powers are. Let's go over what the Constitution says Congress is supposed to do. Let's see. Congress is defined to punish piracies and felonies committed on the high seas. They make laws about that. Declare war, letters of marque, reprisal, make rules concerning captures of land and water. These are all national security issues. Provide and maintain an army and a navy. Those are national security issues. Make rules governing the regulation of the army and the navy. Those are all national security issues. Provide for organizing, arming, and disciplining of the militias. Those are the state institutions which support the Army and the Navy. That's what Congress's powers are. Article 2 goes into what the President's powers are, and it's not all that specific when you get to Article 2. The President's powers are, well, to run the government. He's the President, presides over the executive action of all the government. But the Congress does give him a couple little things, and the Constitution gives him a couple little powers. And first of it, when he takes his oath of office, he says what? I swear and vow I will uphold the Constitution of the United States and protect it against all enemies, foreign and domestic. Doesn't he say something like that? Okay. So in that little speech, that's his powers. He's charged with the responsibility of directing our national resources to protect the country against all foreign powers and domestic powers that may be antagonistic toward the country. So the Constitution gives him the framework, or at least the backbone, with which to address national security issues. Okay, I mentioned there are 3 branches. The judiciary. What role does the judiciary have in this? Anybody have an answer? Well, it has to determine whether or not a law passed by Congress is, one, constitutional, and two, whether an act committed by the executive is within the framework of the Constitution. They make those decisions. So the judiciary sits as kind of an overseer, and we're going to talk about some of what their actions have been as we go through tonight's lecture. But I want to talk about what's taken place really in the last 50 or 60 years. Because post-World War II is the formation of what I call our national intelligence community and the national security interest of the country. Starting in 1947, Congress passed what they call the National Security Act. And it did a number of things. First thing it did, it established the National Security Council. That's a body that works for the president to define policy issues governing national security. Two, it did away with the OSI and established the Central Intelligence Agency. And it created the position of Director of Central Intelligence. It Let's see. It mandated development of disclosure policies and access to information. It demanded a regulation oversight policies. In fact, the National Security Act actually established two separate little committees within Congress. One of them is called the Senate Select Committee on Intelligence, and the other one's called the House Permanent Select Committee, HPSI and CISI, or what they're called, referred to. That was done in 1947. It's been amended several times, and we'll go through some of those actions as they grow up. After the National Security Act came into existence, it was a few years after that, the President issued what we call executive orders, to define some of his procedures to affect what the National Security Act did. It established the policy of national intelligence information. It created classification qualifications and background information to support people who may have access and contact with national security related information. So you have created the classifications of confidential and secret and top secret, and it set out the policy. The executive order has done that. Following that, in 1968, Congress passed what they call the Omnibus Safe Streets and Crime Act of 1968. And it created some policies. It established some criminal acts, incorporated espionage as one of them, into an authorization for electronic surveillance of criminal activity in the United States. Prior to that, there was no statutory formation or judicial oversight per se governing the execution of intelligence-related electronic surveillance. If you wanted to put a wiretap on, there was no court per se, or process per se, prior to 1968 that authorized that. It had all been done by Attorney General or presidential directive. But following 1968 and the Omnibus Safe Streets Act, they created a process called Title III. Has anyone in here ever heard of Title III electronic surveillance? Wiretaps? You have, sir. Yes, sir. You hear about most frequently in some of these drug-related cases. People are monitoring drug-related activity, and they'll use a Title III to acquire the inside information about what the various criminals are doing. It requires a criminal predication for the issuance of that. In 1974, following a lot of the activities that took place, I guess, in the late 60s, Congress passed what they called the Privacy Act. Has anyone here ever heard of the Privacy Act? I hope you have. In conjunction with that was the Freedom of Information Act, 1974. The Privacy Act says what? It says that no government agency may maintain a record about what we do as individual citizens unless it's within the authorized directive of what they're supposed to be doing. That's every agency. And every agency must promulgate rules, and they're published every year as to what their authorized activities are. So you can see, the general public can go out and read those rules of what they're collecting information on. Such that if they're in violation of the Privacy Act, what is that? It's a crime. If a government agency is in violation of the Privacy Act, it's a crime. That all started in 1974. Another act was the Right to Financial Privacy Act. Came out in 1978. In 1976, the Supreme Court in U.S. v. Miller said that an individual has no reasonable expectation of privacy and records about that person maintained by a third party. Such that if a phone company, let's say, for instance, or a bank, for instance, has right to financial privacy, if they were doing business with you and they collected information, they maintain that information, it's their information, it's not your information, although it's about you, there's no reasonable expectation because you don't control it. The bank controls it, or the other party controls it. It could be a hotel, it could be anybody. But for that reason, the Supreme Court said you can't possibly have a reasonable expectation of privacy if somebody else has your information. I mean, how could you possess that? The Supreme Court said that in 1976. Well, in answer to that, in 1978, this Congress said, well, wait a minute, we're not going to have that. We're going to create a expectation of privacy in certain records. And the first one of those was financial records. And the first act that passed was in 1978, the Right to Financial Privacy Act. And they said that an individual shall have, henceforth, a right to privacy related to the financial records. And why is that important? It's important in this way. Most of what the Constitution says, most of what all the statutes say about what the government can't do. There's things, the government can't do this, the government can't do that, unless there's a specific process. Well, that's exactly what this Right to Financial Privacy Act said. It said the government cannot do something unless it fits within a certain statutory framework, i.e., under the Privacy Act, must have an authorized legitimate purpose to be collecting information, and two, a genuine interest and legitimate interest for whatever you're doing to acquire that information. And there's a process for doing that. There are methods, they're all listed, and there are about 10 different methods, including one, just asking the person for the records. You can ask for personal consent to acquire those informations, all the way up to requiring a subpoena or even a court order to acquire them. There's a methodology that statute imparts. That's 1978. It's grown a little bit since then. In 1978, in the same year, Congress passed the the Foreign Intelligence Surveillance Act. And let me give you a lead into that. Most of us in here probably were alive in the late 1960s and early 1970s when there was a lot of turmoil going on in the United States, right? There was public demonstrations, anti-Vietnam War issues. There were some cases involving bombing of government institutions. There were even several cases out there in which the government actually went out and tried to acquire information, some of which was authorized by the Attorney General to conduct electronic surveillance against certain groups who may have been doing or engaged in activities which were antithetic to the established government of the United States. They were out there setting off bombs in college campuses, setting off bombs at power plants, setting off bombs at government agencies. That was going on in the late 1960s and early 70s. Well, the Attorney General in that time frame authorized certain electronic surveillance. And what happened? Well, they were held to be lawful because under the President's national security powers, which are what? Remember what he said? To protect and defend the Constitution of the United States, he can authorize certain things. And he had delegated to the Attorney General the authority to authorize electronic surveillance in certain institutions, in certain instances in which there were nefarious activities ongoing in the agent. Well, that first taken a look at by the courts, because the courts always have to get a role in this, and a case called the Keith decision. It came out in 1972. Some of those activities were reviewed by the court. And the court at that time said, wait a minute, we're citizens of the United States. And there is a Fourth Amendment. And the Fourth Amendment says the people of the United States have a right to be secure in their persons, effects, property, and places, right? That's what the Constitution says. So, and the court's responsible for overseeing that authority. Now we have the President acting on his national security authority, and I'm not going to say he doesn't have it, and the courts didn't say he didn't have it either. They just said there ought to be a method of judicial review if there's going to be a seizure or a search of one's electronic communications. There ought to be. If you're going to get the content, there ought to be a process. So directed by the Keith Court. Congress acted. And in 1978, they passed the Foreign Intelligence Surveillance Act, which gave an established procedure, a process by which government responsible for protecting us can go to a court established to hear these cases and present facts supporting the application for electronic surveillance against a target. And we'll talk about that when we get to it a little bit later. But that came out in 1978. So we've got National Security Act in 1947, Privacy Act in 1974, the Foreign Intelligence Surveillance Act in 1978, the Right to Financial Privacy Act in 1978. But we still have the Miller decision out there, right? And what did I say the Miller decision said? That there's no reasonable expectation of privacy in property maintained by a third party. I can't have an expectation of privacy. I just can't do it. If someone else has my information, how can I personally tell them what to do? Well, Congress said, we've got to do something about that. There are other areas other than financial records which require some protection. And the next one they looked at was electronic communications. And so in 1986, they passed the Electronic Communications Privacy Act, Heretofore, there had not been an act. Government could go and ask a phone company to give them information, and they would do so. But now there's a process. In 1986, Congress said we have to have a process. We're establishing a person's right, expectation of privacy in their electronic communications information. So that came out in 1986. That's not alone. Congress has done more. A couple of years later, they did the same thing with the Fair Credit Reporting Act. And they established a process whereby the government, if it has a need under the Privacy Act, under the established guidelines, to acquire information, to seek an order or a process for obtaining information from a credit bureau related to a person. Okay. After that, we had 2001. What happened in 2001? A couple of people, 19 to be exact, flew planes into the World Trade Center and the Pentagon. Thus encouraged, Congress acted under the President's request and passed the Patriot Act. Protect Americans, all that stuff you've heard of. That act actually amended some of these statutes and added a couple of more to it. Methodologies for the government to acquire information under an authorized process, which the government could rely upon. It addressed the financial records. It addressed the telecommunications records. It addressed, the Fair Credit Reporting records. There were some amendments attached to that. And it went further to create a court order to collect information that would be third-party information. A process, if you would. And they call that business records. So they created a business record statute. It was a part of the Electronic Communications, the FISA statute, and they added an addition to through the Patriot Act, but they actually created a statutory process allowing the government to access third-party record information through an order or a demand for that information. Heretofore, the government couldn't do that. I mean, they could ask for it, but they couldn't compel the production. Now, with a statutory process, they can compel the production of certain information because it fits certain procedural standards. And we'll talk about those as we get along in here. In 2004, Congress went on and did a couple of more things. One, they created the Homeland Security Act, which created a whole new department of the government. It reorganized the intelligence community in some grit, added a few new intelligence community entities out there that we can talk about. And then also in 2004, the Intelligence Reform and Terrorism Prevention Act also established that. And it created a whole new Director of National Intelligence, a whole new position. Heretofore, that had been the Director of Central Intelligence, had held that role. They've elevated it from that role and gave it to a whole new Director of National Intelligence. So that's kind of the framework upon which we went, which national security intelligence kind of national security law is based on, all those statutes which I've just given you. Now we go to how the President has directed that. The President gave us some executive orders. If you go back to the National Security Act of 1947, which essentially established the intelligence community, he defined, for our sake, what the intelligence community is. It established the Central Intelligence Agency. It established the Defense Intelligence Agency, the National Security Agency, the National Reconnaissance Office, the National Geospatial Intelligence Agency, the intelligence and counterintelligence elements of the Army, Navy, and Marine Corps, Air Force, the intelligence elements of the FBI. Now, that's not what it initially said. It just said the FBI was an intelligence, remember the intelligence community. But that's been upgraded. The intelligence and counterintelligence elements of the Coast Guard, the Bureau of Intelligence and Research at the Department of State, the Office of Intelligence and Analysis of the Department of the Treasury, the Office of National Security, that's a new one, came in, the Office of Intelligence and Analysis of the Department of Homeland Security, that's new, came in 2004, the Office of Intelligence and Counterintelligence, Department of Energy, that's actually dates back to the 90s, the Office of Director of National Intelligence, that's the new head intelligence official for the country. That created by that act in 2004. That's the framework. Now, what do they do? How do they work? Let's talk a little bit about electronic surveillance, because that kind of ties in most all the significant cases of national security-related investigations in some form or another, are going to incorporate electronic surveillance, the government's use of electronic surveillance. As I mentioned to you, in 1968, the first act which governed the national government's acquisition of electronic surveillance was the Omnibus Safe Streets Title III legislation, which said if probable cause is out there to say that Lee Leggett is committing a crime so designated by that statute, and there are about 100 different criminal acts designated by the statute, and it is probable cause can be shown that he's using electronic surveillance in furtherance of that activity, or electronic communications in further of that activity, then based on that, then the government may seek an application to wiretap Lee Leggett's phone to collect his criminal activity and record it and document it in that fashion. Well, the process, that's kind of what the process is. You file an application, but there are some processes that go with that. How it is normally done is an application is made, it is submitted to a U.S. attorney in the local level, it's all submitted to the Department of Justice because an application for electronic surveillance requires Department of Justice approval. It says Attorney General in the statute, but it's delegated down to 2 or 3 officials in the Department of Justice, but it requires prior departmental approval before any government electronic surveillance under Title III can be committed. You just can't do it at the local level. You have to go to Washington and seek their permission, so to speak. So you have to have the crime, has to be designated federal crime, has to be one of those particular crimes for which electronic surveillance is authorized by that statute, and an application can be made. That's the first effort by which electronic can be acquired by the government through Title III legislation, starting in 1968. But as I mentioned to you, intelligence-related electronic surveillance is a little bit different because there may not be a specific criminal act underpinning an electronic surveillance for national security purposes. You may want to know what the spy is doing. May not be engaged in criminal activity, but you may want to know what he's doing, right? Would not be a logical thing to know if a spy's in this country, what he's doing, whether he's engaged in criminal activity or not. And one methodology for acquiring that information is likely to try and collect his electronic communication. Who's he talking with? What is he talking about? Seemed like that would be a reasonable thing to do if you knew a spy was in this country. But he may not be engaged in a particular criminal activity, which would underpin a Title III. So when they passed FISA, they provided a process for that. The process says you must be a foreign power or an agent of a foreign power. And it defines what an agent of a foreign power might be. It could be a spy. By definition, a spy would be, I think, an agent of a foreign power. So in essence, the criminal nexus for electronic surveillance is trumped by the national security need for acquisition of electronic. Thus, the FISA statute is a little bit different from the criminal elements of Title III. It imparts a national security intelligence-related focus for acquiring electronic surveillance. And that act, much like Title III does, established a process, a rather lengthy and arduous process for the government to get the authority through a court for the conduct of that kind of electronic surveillance. But it is a separate and distinct process. And there's a rationale for that. If it is not for a criminal purpose, using a criminal tool might well be an unauthorized activity under the Privacy Act, would it not be? Unless it's an authorized purpose, use of a criminal tool might not be. So you might be violating the law where you use one application versus another. So there are two distinct processes or methodologies for acquiring electronic surveillance. You had a question, sir?
Does it matter if a person that was a spy is a citizen or not?
Well, we're going to talk about that. That's a good question. Because the citizen requirement under the FISA statute requires that there be a particular criminal nexus. The statute writes in that. If it is a U.S. citizen or a U.S. person, and need not necessarily be a citizen, it could be a U.S. person, there must be a criminal nexus to the need for acquiring that information, as opposed to a foreign national. That distinction is made. Sorry? Okay. The question was, if there is a U.S. person, does the non-criminal element aspect of FISA apply? And the answer to that question is no. If it is a U.S. person, there must be defined in the application a criminal nexus to that U.S. person's activity. On the other hand, if it is a foreign national, and usually spies are foreign nationals, not being a U.S. person, that would not attach. There just have to be an intelligence-related focus to it. Now, a little bit about the process, how that application is, what are the steps that are required for that? There must be an application, whoever the investigator agency is, and the application is presented to the Attorney General, one of 3 officials in the Department of Justice, who must approve it. The intelligence-related purpose for that must be certified to by one of, I think it's 9 individuals who hold executive positions in the government. The Director of National Intelligence would be one, the Secretary of State would be one, the Secretary of Defense would be one, the Director of Central Intelligence would be one, the Director of the FBI would be one. Individuals of that level must certify to the court that it is for intelligence-related purposes and authorized under the Privacy Act issues relative to an authorized investigative effort by the government. Must be approved by the Attorney General and must be submitted to the FISA court. Yes, sir.
Does any of that have to go through the IRS?
The question was, does any of that have to go through the IRS? The answer to that question is no. Specifically, the IRS is not a member of the intelligence community. Well, not of the defined intelligence community. Okay.
What if the foreign national is not a representative of the foreign government?
Okay. Well, there are definitions of what a foreign power is. For instance, certain terrorist organizations are not representative of a foreign government, but they are, by definition, a foreign power. Hezbollah is probably a foreign power. The Abu Nidal organization is probably a foreign power. I don't know, I'm just naming them because I see them written out there. But I would suspect they would be classified as a foreign power, as opposed to a government, for instance, the government of Iran, the government of Germany, the government of South Africa. Those would be legitimate governments and their entities. But there are going to be entities out there which may or may not be wholly directive of a national government power. And that gets a little bit kind of muddy because there are entities out there which would appear to be private business concerns, but are probably controlled by foreign governments or foreign powers. And so how that's defined could be interesting, to answer your question. Okay. So that's kind of the process. That's how that works. There must be an application made defining the nature of what you're trying to get, whether or not it's a foreign power or an agent of a foreign power. You have to define all that. And then all that process has to be approved by very senior government officials before the application is made. And then it goes before a court. Now, there are 11 judges that hear these matters. They're appointed by the president, and they're all U.S. District Court judges from around the country. 3 of them must be from the Washington, D.C. area, because that tends to be where most of these cases tend to generate. So you want to have a judge that's convenient. But they actually ride on a circuit, and they're from around the country. There are 11 U.S. District Court judges who sit on the FISA court, and they will hear these cases. Interestingly enough, if you go back in time, I think prior to 1978, there were not so many Attorney General or presidential authorized electronic surveillances. Once the statute came into being, defining a process, it became an actual available tool, a more readily available tool for the government to use and protect our national security. Because there was an established process which could be followed, and then orders could be obtained, assuming there was sufficient information introduced to support an application. Yes?
How long does this process take? I mean, from the time something is identified,
Okay.
they go through all these steps.
Okay, well, I did a study once. It can take anywhere, if you get the planets lined up. Keep in mind, you're going to have the Attorney General lined up, either the Secretary of State or Director of the FBI or Director of Central Intelligence lined up for their approvals, the written documents lined up. It can be done, if it's an emergency, in short order, very short order. The average time process, I would guess several months on the average case. But don't quote me on that, I'm just guessing. Because there are a lot of drawbacks to it. I mean, a lot of institutionalized bureaucracy that are innate to this. There are a number of approvals, not just their approvals. You have to work its way. Each agency is going to have their separate individuals approving. At my level, it might have been a supervisory position. I might have had to say yes, and then ask my boss or some boss above me along the line. And that process takes time. The applications are quite lengthy. You have to go into your investigation, why you think it's necessary, what you hope to gain. They can be very detailed and quite lengthy because that's demanded, because you're looking at using a very intrusive technique to acquire information, and that's done.
So if there's imminent danger, will this process be speeded up?
Okay. The question is, if there will be an imminent danger, can the process be speeded up? If there is imminent danger, the process will be speeded up. Because if you're talking about imminent danger, and I think we're talking national security, you're talking about areas which elevate to real horrendous potential actions. And so if you're faced with a confrontation of an act which imperils a large number of our citizens, then yes, the answer to that question is it can be accelerated quite quickly. But again, you have to line up the planets, and the planets are oftentimes hard to track. I mean, these are high government officials, or you kind of know where they're at, but you may not know where they're at right now. Yes, ma'am, you have a question.
The NSA, don't they already have all this information on the cell phones?
Okay, we'll talk. Let me. Okay, we're going to go into that. The question was, doesn't the NSA already have all this information? The answer to that question is no, they do not. And we'll go into that in just a minute.
You said that one of the 9 people have to approve. Can they delegate?
The answer is no. Those who are designated cannot delegate it. The Attorney General approval process, there are, I think, 7 in the chain who can approve for the Attorney General. They're all the Deputy Assistant Attorney Generals. And they are at a level where they're all approved by the Senate in terms of confirming their position at that level. But the various agencies or certifying authorities are specifically designated by the President in his executive order, and only those people can approve the process for intelligence. Yes, ma'am.
Where are the records kept of these cases?
Ooh, well, that's
And are they confidential forever?
okay. Well, I can answer that. The question was, where are the records kept regarding these cases? Well, it depends on the agency which is involved. If it is the FBI, they're maintained by the FBI in their record system, and they'll be maintained. I won't say for forever, but until such time as there's a destruction policy governing their destruction. That may be done by court order. It may be done by an established policy which the agency may hold. If it is another agency, you mentioned the NSA, they would have their own little record policy with regard to destruction of their records, and I would assume they would probably maintain them, oftentimes for a number of reasons, until whatever their destruction policy may designate for that information.
How would you rate the cooperation between those agencies? How would you rate the quality of cooperation?
The question is, how would I relate the quality of cooperation between agencies? Well, post-2001, it's a lot better than it used to be. I will say that. And that's just inherent. I mean, each agency is responsible for doing certain things, and consequently, wanting to maintain the integrity of what they've done vis-a-vis some other agency. When we looked at the executive order, we talked in terms of the establishment of the intelligence community. Each member of the intelligence community has a little piece of the pie. The Central Intelligence Agency is responsible for the collection of counterintelligence and outside the United States, not so much within the United States. The FBI is responsible for collecting information like that within the United States. And there are several other agencies out there. Defense Intelligence, if it's related to the military, they have a little piece of the pie. The Army Navy Intelligence components, they have a little piece of the pie. If it involves the Department of Energy, they have a small piece of the pie. Usually that's shared with the other agencies. They're very good about that. The Treasury, if they have an issue, usually used to be through Customs, but that's been reorganized under the Act. They have a small piece of the pie. They will share that information. The Department of State also has a very small piece of the pie, but they will share that. Nearly not as large as what the FBI's role would be or what the CIA's role would be, but they all have a place to play in that. And I think the answer to your question was, is there a sharing information? I think from what I read, it's a lot better than it used to be. There are even efforts, I know, to share information to the extent that it can be with state and local authorities involved, which is much improved over what it used to be. Yes, sir.
If one agency like the FBI gets approval for electronic surveillance, can another agency piggyback on that approval?
Well, no, you can't piggyback. I mean, it's approval. They're either authorized to or they're not authorized to. It would be separate agencies doing that. But the question, as the young woman asked earlier, can some of that information be shared? If it falls within what I would call the Privacy Act restrictions on sharing information, if it falls within the parameters of what can be shared, then it would probably be shared. Yes, ma'am.
Aren't all records now computerized?
The question is, aren't all records computerized? I don't know the answer to that question. I think largely they are. We've evolved technologically in the last 20 years far from where we were when I was active writing little notes and things on sheets of paper and storing them somewhere. I suspect a lot of that is probably electronically stored. And in the future, certainly, most all of it will be electronically stored. Okay? Any questions on that? Because we can get to it again. Okay. Well, I mentioned to you that all these activities have to be oversight. There must be some overseer relative to what's going on. And the relative overseers are Congress. I mentioned they have the HPSI, House Permanent Select Committee on Intelligence, and the Senate Select Committee on Intelligence. They oversee all the activities of the Intelligence Committee. There are meetings in secret. Some of them are in skipped areas. Some of them are actually in open and conversation with these committees to govern what the activities of the various members of the intelligence community are doing. Each member of the intelligence community, whether it be the FBI, the CIA, the Department of Energy, they have to go before the committees and advise them on a continuous basis what's the current activity, what they're doing, what they're looking at and why, and what's going on. And those committees provide oversight. In addition to those committees, the President also has his own oversight bodies relative to what I would call the lawfulness of certain activities that are ongoing. And that's the created by executive order, or the President's Intelligence Oversight Board and the President's Privacy Board. They're all tied together, civil interest of the President. He wants to make sure that the various agencies are conducting their investigative authorities within the framework of what the statutes allow them to do, within the framework of what the executive orders permit them to do, within the framework of what the various regulations imposed and imparted on them are to do. And these bodies are apart from the government. They're actually private individuals sitting as citizens, so it's not like a government chain. The board members are significant individuals appointed by the President to have access to certain information, to oversee the integrity of what the government is doing. And they report to him on a monthly basis. And they have free access to most everything that these agencies are doing. They're selected individuals for that purpose. I've met with them in my past history, and they're all extremely interested in what's going on and provide excellent questions. Very bright people along that line. So the President has his own Intelligence Oversight Board. Congress has its oversight board on both the Senate and the House side. And then again, the judiciary, when questions are caught and brought before them, they have an oversight issue relative to what's going on by the intelligence community. And they act as a checks and balance kind of effort for that. The current House Permanent Select Committee chairman is Mike Rogers, who's a Republican from Michigan. The Senate chair is from California, Senator Dianne Feinstein. And you've seen them, I know, in the last 6 months on television a good bit, talking about what's been going on in the world. And we've had a number of issues, and someone mentioned the NSA question. Maybe we'll go right to it. Now, as I understand it, the NSA has collected a large body of what they characterize as metadata from electronic communications. Now, why would they do that? Let's create a scenario. Let's suppose someone says Lee Leggett was in touch with people about setting off a bomb in the subway system of New York City, and this conversation took place 6 months ago. Well, it might be helpful to see if there's any information 6 months ago about Lee Leggett making plans to do something. I'm guessing, just from an investigative standpoint, wouldn't that be a logical thing to do? To try, if Lee Leggett's reported to be trying to put together a cabal of people to go out and do some nefarious act, it'd be nice to go back 6 months to see if you can find out who he's talking to. Well, that's not always easy to do. Metadata is, does anybody know what metadata is? It's just, it's data that the electronic communications carriers use to transfer a message from point A to point B. It's not necessarily the message, it's the data that says we went through this path to that path to that path to that path to get from point A to point B. It attaches to communication, but it's not necessarily the communication itself, but it does support some information that the common carriers can use. How they route messages, how it gets from here to there, the fact that at such and such a time it took place, if it's at such and such a time of bulwark on this carrier, maybe it has to be routed another way in a nanosecond to get to point B. That's the metadata. An action actually occurred. Well, what it can do, metadata can do, is say it started here and it ended up here.
Can you specifically tell us what this Eric Snowden did? I cannot quite grasp.
Okay.
I understand that he leaked a lot of information
Okay.
with the government.
Well, I was headed in that direction. So let me go back to where we're at with this metadata collection. Because the NSA got, I think, authority to acquire metadata collection. And that would be all metadata collection, not just Lee Leggett's metadata, all metadata collection. And why would the NSA do that? Remember the scenario I said? We got a plotting of Lee Leggett trying to do some nefarious act like 6 months ago? Well, metadata is not necessarily maintained by the electronic communication carriers. They do not store that or keep it because they don't bill on metadata. They bill on, was the call made or whatever, was it successful or not, or they bill on the fact that you have access to their services. But whether it goes from this exchange to that exchange, they don't necessarily bill on that. So there's no real reason for a common carrier to maintain that data. However, if you build into my scenario, and I think that's probably what the NSA did, I don't know this, but I'm guessing, they said, wait a second, if there's a potential out there for us to collect this information, the metadata, the fact that these communications occur, maybe, given a fact situation that it requires us to go back and see if we have the information, it might be good for us to have that. Because if the phone companies don't keep it, it's like it never existed. You can't go back unless you maintain it. So I would say the NSA asked to collect all the forests in the trees, all the trees in the forest, so they might go back and look for a particular tree, given a particular fact pattern. You have a question, yes, sir?
Where and when and by what process did they get the authorization to do this?
Well, let's figure out, I don't know, but let me figure out what I think probably what it is. Okay, they probably would go to Congress, and they would probably go to the president and ask for an order allowing them to acquire this information, and then set up a process whereby they can access that information. Because acquisition is one thing, using it is something else. And keep in mind, the Privacy Act still sits out there. Agencies can only maintain that which they're authorized to do for a practical purpose. And from what I've heard Ms. Feinstein say and Mr. Rogers say, there was a process developed for the government to use to acquire that information. Keep in mind, it's a big storage bin. All this metadata is a huge bin of information. And it's not necessarily, as I understand, it's not the content. It's not what we're conversing about. It's the fact that Lee Leggett may have talked with Mr. Brinkley, at such and such a date and such a time. Because it will be able to identify Lee's number and Mr. Brinkley's number. It won't say what they're talking about, but it will show the connectivity. And oftentimes, given that kind of a scenario, which I mentioned earlier, what you want to find out is the connectivity and then build up from an investigative standpoint. So I think that's probably what it was all about. I think they acquired authority, I think probably from Congress, probably from the president, maybe not from Congress. I think under the Article 2, the president says he has that power. That's been an ongoing debate back and forth for years and years and years. It crops up every 4 years, every time there's an election. But there is a legitimate argument out there that the president, when he swears the oath of office, under his Article 2 powers, he's defined to protect the Constitution of the United States. He's going to do what deems necessary to do that. So let's assume there's some order out there, I'm sure, it wasn't just to collect all this metadata. It's just metadata. It's just widgets that go out and back and forth. Yes, sir.
Sir, you mentioned a couple of times your name from this name to that name. I believe what you're saying is the metadata is from this instrument.
That's correct.
to that instrument,
That's correct.
not who's on each end of the line.
That is correct. The statement was the metadata does not actually identify Lee Leggett or Alan Brinkley. It would identify an instrument used perhaps by Lee Leggett and also used by Alan Brinkley. It would just be this number and that number. It would be the ones and twos which are transferred over the electronic spectrum. Okay, not who's on the other end. But it would show a pattern. And if you can figure out those numbers, then it's possible at some point with additional investigative effort to acquire who may be on the other end of those lines. That's the process. Yes, ma'am.
I remember something about certain keywords that the FBI picks up on.
Well, that's probably not the FBI. That's probably NSA that's working on keywords. And assuming that's what it is, given that scenario, you're looking for certain information in this forest of trees, looking for something that may mention that.
But that's not metadata.
Well, it would be. It might well be. Well, how to answer that question? Okay. Well, we're talking different issues then. We're talking different issues. Because I think the one that you're well, there are some conversations, you're absolutely correct, that are acquired. Because text communications are transferred by metadata. And, it's just ones and twos they're going over. It's not actual conversation. It's when you, I guess, use the phone. I don't understand how it works, but it is text. Is going to be metadata. It's transferred by metadata. So you may be able to get if it's in this forest of information, words that may have been typed out there somewhere. I don't know how that works, but that may be possible. From what you said, I think text messages are actually transferred through metadata. These little signals create an impression at the other end of the line, which would be transferred as metadata. Not so much voice communications, because they work on a different spectrum than ones and twos.
Does that include other means of communication like email?
It could. It could include other communication like email. I think that was another one of the issues that we've read about. The NSA is collecting perhaps some email, although that's not necessarily through metadata. That is under specific orders. As I understand, they were acquiring certain information, which I think have been provided either by the president or the courts. And I'm not familiar with that. I have no knowledge of what they actually did relative to email transmissions. I know there have been some balking. I think Google reported that they received some order which they did not want to respond to. But I don't know, I have no information about per se what that is. When I'm talking about the metadata, though, and how that works, and I think this was the original information that related to Mr. Snowden, was it is information about my phone calls, your phone calls, because it's in this big tree of forest. What I understand from listening to what they said, at least on the Hill, was that there was a process, once this information, that the government could use to acquire that information. They've already acquired it, but to make it useful, you have to go in and do that little search. And that would require some court order. That would require a procedural process to give access to that which they've collected. Therein lies the rub. At what point is it acquired? Is it acquired when they initially grab all the trees in the forest, or when they go in to look at it based on a court order? And I think that's what's up for debate, even as we speak, right now. Yes, sir.
The discrepancy I'm hearing is the fact that you're saying a court order is required, and pretty much on an individual basis, yet the government has done this in mass authority.
Well, I think, I guess the government would probably say, at what point do you consider it to be acquisition? And from their investigative purposes, from their useful purposes, it would be based upon their access of that collected information based upon a court order, not the initial acquisition of it. I know that seems kind of funny, but I believe that's, from what I understand, is actually what's taken place. Pardon me?
Sounds sort of government's what it sounds.
Well, yes, but I mean, if you keep in mind the process that the government can only maintain certain information unless it fits within the authorized use of their purpose, this acquisition creates a forest. It just creates a forest. Their argument would be that we're not really accessing it until we go in to look in this forest to see what we've collected. I mean, if there's billions and billions of these little digits out there, no one's really looking at those billions and billions of digits until they say, hey, we've got an issue. We need to see if in these billions and billions of digits there might be something. And that would require a court order to access the collected billions and billions of digits. Does that answer your question?
We have time for one more question.
Okay. Yes, sir.
Our emails are maintained by Google and Microsoft. Do we have a reasonable expectation of privacy on our emails?
Well, what I mentioned to you, that there are certain statutes out there which the government has passed to impart a reasonable expectation of privacy. And one of those is the Electronic Communications Privacy Act, passed in 1986. And it talks in terms of communications common carriers. If you define Google email and Yahoo email and AOL email as a common carrier allowing the transfer of communications, then it would seem to me that the Electronic Communications Privacy Act would probably establish a right to an expectation, a reasonable expectation of privacy in those communications, requiring a court order to gain access to them. And a court order either under Title III of the Omnibus Title III electronic surveillance or a FISA authorized electronic surveillance to acquire that information. Yes, ma'am.
On the Edward Snowden case.
Yes.
What information was he actually able to give to the Russians?
Okay, well, I don't know. From what I've read is all this stuff that they collected, for some reason he had access to that. He had access to that. And so he could go in and do an acquisition of it, yet for whatever that. Can he do that legally? No, it's against the law what he did. That's a crime under the Privacy Act, under various other acts as well. But he had individual access to it, and he could do it. And apparently he could download that to little thumb drives, because you can store an awful lot of data on a thumb drive. You get a 16 gig, I don't know, it's millions of documents probably storable on that. Apparently he was able to do that as well.
He could be still doing it.
Well, I hope his access is limited since he's somewhere abroad now. Yes. Any other questions?
I have one question.
Yes, ma'am.
Is this type of information exempt from the Freedom of Information Act?
Well, there are no exemptions. Well, I say that. That's not exactly true. There are limited exemptions from the Freedom of Information Act. I mean, if you're looking at it, I would make a request and see what happens. I mean, that's because, as Alan mentioned to you, I serve as the county magistrate. That's my retirement job. I'm county magistrate here in Madison County, which is a great place to be. It's a great job, perfect for me, because it keeps me in touch with law enforcement, which is a large part of my background for the last 30-some-odd years is working with law enforcement. So I get to see them on a day-to-day basis. And so let me give you this little story. About a couple of weeks ago, I had one of the state troopers come in to see me, as they're wont to do. They do their tickets and whatever, and we chat from one another. And he imparted this story to me about, have you ever gone like to Mississippi on Highway 24, going through Russellville that way? Have y'all ever driven that way? They're always working on the road. It's a bumpy road. It's a very bumpy road. He was out there doing his path, and he came upon this car going at a very high rate of speed. And so he pulled up beside him, pulled him over, and stopped him. And inside the car was this man who's driving the car, and right next to him was a little bitty pig sitting right in the passenger seat, right next to the driver. And so he said, now, man, sir, you are going way too fast. What in the world would cause you to drive at such a high rate of speed on Highway 24 going west towards Mississippi? He said, well, obviously you have to understand what's happened. I was traveling down this road, and I was behind this truck, and this truck was just loaded with a bunch of little pigs on it. And we hit this bumpy section of the road, and this one little pig fell off the back. I pulled over, picked up the pig, put him here in the passenger seat. I've been trying to catch up with that truck. Okay. Well, the officer says, well, I pulled you over. You're never going to catch that truck. What you ought to do is just take that pig down to the zoo in Birmingham and give it to the zoo. Okay, so that's what I'll do, officer. Promise, don't give me a ticket. Well, lo and behold, about a week later, traveling on that same highway, this officer is going behind this car, going another high rate of speed, pulls the guy over. It happened to be the same guy as before, right? Okay? Okay. And sitting next to him happened to be the same little pig. Okay. So he asked the officer, says, officer, and he says, I know, and the officer says, well, didn't I just stop you on this road about 2 weeks ago? And the guy says, yeah, you did. I was going at high rate of speed then. He says, and at that same time, didn't you have this little pig next to you? And I said, yeah, I did. And then he said, well, and didn't I tell you to take that pig down to the zoo in Birmingham? He says, yeah, you did. And I did, and we had such a good time. Now we're going to Six Flags.
Thank you so much.
Okay.
Thank you.